Michael Lynk is Professor Emeritus at Western University in London, Ontario. He's joining us live from there. Thank you very much indeed for being with us. If I understand it correctly, this is the first time that Israel has been in front of the ICJ, or in fact any other court, international court, as a perpetrator rather than as a victim. How do you assess the significance of what we're seeing over the next couple of days?
Well, Israel obviously has understood that this isn't simply a legal case, but it's a political case playing out on the theater of public opinion around the world. It thinks, I think, that it has some case to be able to make in arguing back to South Africa. It's going to argue, I suspect tomorrow, this is an educated guess, that it will probably use footage from what happened on October 7th, and it also will argue self-defense. Those would be probably the best two arguments I can think of that Israel will wind up raising. But it recognizes the huge reputational consequences of any finding by the court in provisional measures with respect to a plausible case of genocide being found against it. So this is why it has, contrary to its previous pattern, shown up to want to be able to argue this at the court. And as I said, I suspect we'll see plenty of arguments around those two particular issues. That something atrocious happened on October 7th, and Israel had the right and the necessity to defend its people by going after Hamas in Gaza.
I want to kind of expand on that a little bit, just for viewers who are joining us and maybe just trying to catch up with what's been going on in The Hague. If I understand it from what you're saying, Israel's claim will be based on its justification for the action that it took, based on the Hamas-led attack into southern Israel that happened on October the 7th, against the South African case, which is actually based on the nature and the scale of Israel's response. Is that fair?
Oh, look, when you're in a weak position as a lawyer representing a client, you want to try to argue your very best facts and focus and try to get the court to focus on those and draw them away from the arguments, the facts, and the law that the other side has done. I must say, having watched the South African presentation of the day, this really was a top drawer case example of advocacy. All of the lawyers laid out an extremely persuasive and strongly made case, and that reflects, the top drawer application that South Africa made 2 weeks ago to the court. 84 pages, single-spaced, over 560 footnotes, arguing the facts and the law and the need for a provisional measures. And that was all echoed today by the lawyers in very calm, measured fashion as they presented before the court as to why the atrocities, they said, that are being laid out on the television screens and the computer screens around the world needed to be stopped. That was an exceptionally persuasive case put to the court. And if I was Israel, then I'm going to focus on what I think are my strong points, which is October 7th and the right of self-defense.
Prime Minister Benjamin Netanyahu of Israel has already come out rejecting the hearings themselves. There has been a suggestion that they are baseless, I believe is the word that the US has used in relation to them. If the court, given the fact that this is not binding, if the court finds in favour of South Africa, but Israel chooses to essentially ignore that ruling, what do you think that tells us about the state of international justice? What kind of perception would people have of it at that point?
Interesting you say that, because among the very last points made by the lawyers representing South Africa today was that the very reputation of international law itself hangs in the balance with the decision to be made by the ICJ on the South African request. And they laid out, both in the written application and in some of the arguments made, the number of times that Israel has defied resolutions coming from the Security Council, from the General Assembly, and also Israel's defiance of the ruling made almost 20 years ago by the International Court of Justice with respect to the location of Israel's wall that it's building inside the the occupied West Bank. So all of those were repeated reminders made by the South African lawyers with respect to the reputation of international law. And I thought that was an exceptionally incisive point that I'm sure many of the judges will be considering with respect to this. You know, the court is a legal court. The judges are well trained in the law and international law in particular, but they're mindful of the court's reputation, and they're mindful of obviously that Israel and the United States has taken strong exception to the ICJ hearing this case. But it's also mindful of the fact that South Africa has an outsized reputation in the world, that it's bringing this as a, if you like, a disinterested party to the conflict in the Middle East, and it's making this compelling case about the centrality of international law. If you're going to make any argument that's going to be listened to very closely by a judge on an international court, it's about the way in which international law has to be protected and has to be enhanced in this world.
Michael Lynk is Professor Emeritus at Western University in London, Ontario. So we appreciate it. Thank you very much indeed.
Thank you for having me.